Okay, lovely. Looks like we're live. Sorry everyone for the wait. We experienced some technical issues with sharing of the screen and so on. But now we've overcome that. So without much further ado, thank you very much for all joining. The lecture series number 5 for the IMG series, this time in partnership with the Medical Defence Union. And we are proud to present Dr. Nandasoma today, who will be giving the lecture or webinar. He's a medical legal advisor at the MDU and has been since 2008, and therefore is very knowledgeable about indemnity and the cover they provide at the MDU. So just as a layout, well, as I'm sure you'll have questions that you'd want to ask throughout the presentation, if you could all mute your mics, I'm assuming that's already happened. The comment box section can be used for any questions that you have throughout the lecture, and we'll try our best to keep an eye on that, and at appropriate sections we'll get Dr. Nandasoma to address those appropriately. So I think without any further ado, let's get started. Are you ready, Dr. Nandasoma?
Yeah, ready to go.
Okay, let's get please let us know. Sorry, just a second. My computer's a bit slow. Okay. Okay, lovely.
Great, Alvin. Will it go into a slideshow?
Yes, so like this. Can everything be seen?
I can see it. It's still in the kind of protected view. I think it's not gone into a slideshow yet, but never mind. I think we can read them. Well, first of all, thank you everybody for your patience, and thank you to you guys at Mind the Bleep for inviting us to talk. Now, you'll probably see from the kind of learning points on the presentation, there seems to be a kind of heavy sell on, joining the MDU or joining the defence organisation, and I'm certainly not going to take up an hour of your time on that. I wanted to do something a bit more productive today and to talk to you about the kind of medico-legal landscape in the UK, talk through a whole range of topics that touch on the things that you come across in day-to-day practice, and Alvin and Divya hopefully can hold me to account on that, whether they're things that you come across. The intention is not that you go away with a complete knowledge of how medico-legally things work in the UK, but just an awareness of the things that you might come across, sources of information and advice, and how to how to deal with that. So if we can, is it possible to start the slideshow? And
yeah,
I've got some commentary about buzzing, so I don't know whether trying to mute your mic might help with that.
Sorry, could you repeat that again?
There's a comment about loud buzzing on the chat, so could you try muting your microphone, Alvin, and then
yes, I will see how I can do that. So just a second. I managed to stop the share first.
Oh yes, I appreciate that. To stop share screen.
Sorry about that. Okay.
Yeah, that's worked, Alvin. That's worked. So it's obviously feedback at that end. Pietro, thank you for flagging that up. That's great. So we'll get back on shortly, and we'll either work through the slides. If it can go into slideshow mode, that'll probably make it a bit easier to read. Alvin, can we sort of go on slideshow and start with that? Will that work? No, we'll work with this. Well, look, what I'm going to talk to you about is, first of all, a couple of practical medico-legal challenges. So we're going to talk about patient confidentiality, a bit about prescribing, professional boundaries, chaperones, and a comment about consent and mental capacity, the law in the UK around that, it can be quite complicated. And the concepts there are things which I think it's helpful to introduce early on to anybody thinking of working in the UK. So if we go on to the next slide, the multiple jeopardy slide. Sorry, I think we're still on the first slide. Alvin, if I can, yeah, we've got on to the next one. That's great. So this is not intended to be a scary slide, but it's something that I think that will surprise people who've not worked in the UK, that if a single clinical incident happens, there are sometimes instances where lots of different things can arise from it. So in every country in the world, doctors can be sued typically, and this is what we mean by a civil claim, a doctor being sued by a patient or another organisation for what they've done if they're said to be negligent in care. However, there are that used to be the thing that 20 years ago a doctor would have found most threatening. But now it's possible for a doctor to face complaints. Now they're quite common in practice. We'll all have complaints over the course of our career. I've certainly had them from clinical practice. A doctor can face investigation by a regulator. And I know worldwide regulators vary greatly in terms of how interventionist they are, how much they involve themselves in day-to-day life. And I would say the GMC in the UK are quite interventionist and do get involved in a lot of cases. When a patient died, if it's an unnatural death, we have the coroner system, whose purpose is to work out who died, where they died, and how they came about their death. And some of those inquests are really straightforward. Others can be really difficult for doctors. We also have organisations in England, also in Wales, Scotland and Northern Ireland, that look at the quality of healthcare in organisations, and sometimes doctors are drawn into those processes. Very occasionally, doctors face criminal investigations. I'm talking about chaperones today because the commonest one is that a doctor is accused of an inappropriate action during a clinical examination, say, for example, a sexual assault. Doctors are sometimes investigated on manslaughter charges where there are significant sort of clinical incidents. That, I would say, though, is still very rare. Extremely difficult if you happen to be involved, but rare. So the first, if I have the next slide, please. I know it will take a bit of time to adjust. So it's not moved on to slide 7 as yet. Maybe it's a bit of lag. Yeah, here we go. So the first concept I want to introduce is that doctors have multiple lines of accountability. So it's not just the medical regulator, the GMC. The doctors have to follow the law of the land like every other citizen, and I'm sure that's the same around the world. Doctors are also held to account by their employer. So if you're employed by a hospital or work in a GP practice, those who kind of pay your wages will have expectations of you and policies about confidentiality, dealing with certain things in the workplace that will expect to be done in a certain way, and you're held to account. We've got the coroner who looks at deaths, and you saw lots of other things on that slide. So I guess the first thing to say is there's quite a bit to think about in these situations. So if we go on to, probably onto slide 9 makes most sense here. Great, thank you. So I'm going to talk about the GMC first. First of all, if we go on slide 10, what does the GMC do? So it has a number of purposes. The GMC sets standards for medical education. It helps set some syllabuses. It sets expectations for medical schools. It deals with registration and licensing. So it holds the list of doctors who or of people who are medically qualified and are registered with the GMC, have a license to practice medicine. It deals with a process called revalidation. And this is what allows you to maintain your license to practice. The license to practice is essentially what lets you see, treat, and prescribe for patients. And the process in the UK for maintaining that is having a system of appraisal, most typically done through your employer, and having a recommendation made by a senior doctor, termed the responsible officer at that organisation, that recommends to the GMC that you maintain your licence. Now, there are other ways to doing it. They are usually much more complicated, but that's the basic way that works. The other thing that the GMC does is produce guidance, an awful lot of guidance, in fact. And the relevance of that is not only that it's sometimes helpful in terms of practice, but it is also a standard that you can be judged against if you deviate from it. And that's their other role, which is what often hits the press the most, is the regulation of doctors and fitness to practice procedures, where you hear if a doctor has been erased from the register, has their ability to practice medicine taken away, it will be usually following a fitness to practice process that the GMC has run. So in terms of preparation for UK practice, if you did one thing in the medical legal sphere, it would be to read this document. This is the GMC's core guidance in good medical practice. It was updated in 2013, and it's going to be updated and published later this year again. So there will be changes to it. The core of it looks very similar to what it is now, but that's the one thing I would do. If we have the next slide. If you're feeling really enthusiastic, I would look at these other documents. They provide guidance on confidentiality, and that's a really common thing you'll come across. There's issue that they also have guidance on consent, and that's, again, a common cause of dispute and a really important thing to think about. And they also have guidance about treating children that's relevant to all doctors. They produce vast amounts of guidance. There are hundreds and hundreds of pages of it in different things. I think these are the key documents that you'd read, and the other things you can access online or look up if you have a particular question or concerning. Now, I'm going to put forward a scenario. The point about this is really to show how medical regulation can extend beyond the workplace. So this is a doctor on a night out visiting friends in London, has a little bit too much alcohol to drink and ends up in an altercation at a nightclub. The police are called. The situation de-escalates, but the doctor accepts a fixed penalty notice of £90 for being drunk and disorderly in a public place. Now, many of you might be thinking, what on earth has this really got? It's a bit ill-judged, and perhaps it's not how we'd all want to be in our best state. But what's this got really to do with care of patients? But if we have the next slide. The GMC do require that doctors tell them if anywhere in the world they have been charged, let alone convicted, but charged with a criminal offence, or if you have registration in two different countries. A lot of doctors in the UK have registration in another country, often Ireland, perhaps India, etc. If there is a finding made against them in that other jurisdiction, the GMC puts an obligation on us as practitioners to tell the GMC that we've been the subject of those findings. So the only point I'd make across here is that medical regulation in the UK can also reach into your personal life. You can have circumstances on things such as this. You can have, other driving offences, particularly driving under the influence of alcohol, can do that, but also issues arising from personal family life, particularly things relating to, say, neglect of children, domestic violence, etc. All are things the regulator can take seriously, and they will communicate with registration bodies overseas. So be mindful of that. Check out that guidance, and really the message is that the burden of registration actually goes beyond the workplace for doctors, and that's a really important thing to remember. So the next topic I'll talk about is confidentiality. And again, most of us intuitively know that medical services are intended to be managed in a confidential way, and that the information that we are in a privileged position to receive about patients should be treated in that way. But there are subtleties to this, and there are things where I've seen doctors who are just trying to be helpful run into problems because of that. So think about this scenario. You're a doctor in training working in general surgery. One of the team secretaries is worried about their mother who had an echocardiogram a few weeks ago under the cardiology team. They've not had an appointment or the result, and says, can you look this up and tell me what the result is because my mother's worried? This is the sort of request I got, I would say, not all that infrequently. And you've got to be mindful of things like this. Here, you might say, well, I've got the permission of the relative to look at it, but I'd say you need to go back to first principles. Here, do you have the consent of the patient, this person's mother, to look at the records? In some instances, you might, but is that still okay? Because when you access computer systems at work, it's usually only for the care of patients that you have a direct responsibility to. Most hospitals in the UK in that situation would say what you should do is perfectly reasonable for you to advocate for that person by contacting the cardiology team and saying, look, I've had this inquiry, can you look at it? But that you shouldn't be using your own access to the system to look at your own results, that of relatives or inquirers in that way, unless you had a direct interest in the care of that patient. So there can be subtleties to this that can catch people out trying to do the right thing. So when you look at this, when you're asked for information about a patient, think about, do you have that person's consent? Is there a mandate by the law to disclose the information, or have you been asked to do so by a court? Or is there a public interest that information must be disclosed? Public interest is a really odd terminology. It doesn't really mean what the public are interested in. It doesn't really mean that at all. What it means is there a wider public purpose in you sharing that information? And that can most commonly be if, say, there is a direct threat of violence to somebody that you have to disclose to protect that person from death or serious harm. So again, if we have the next slide, again, I can't in an hour sort of equip you with everything there is to know about confidentiality. That'd be probably a series of webinars. But again, there's GMC guidance. There is an NHS code of practice, which is really detailed. And I've flagged this up for any of you who come to work in paediatrics or general practice. One of the commonest inquiries our members get, doctors working in sort of general practice or in hospitals, is often requests for practitioners to provide information to social services who are involved in safeguarding children or child protection. And there is specific guidance available in some detail about on how to do that. So if we have the next slide, that's just a visual of where you can get information about where those pieces of guidance are. I'd say that the GMC guidance is by far the most sort of accessible point. But the other main message is that, look, if you have an inquiry and you're really not sure how you should respond to it, get advice from a senior colleague, because almost certainly they would have come across that situation before. And, you know, for doctors who are our members, we always say, look, ring us. We're very happy to talk about these things. And it's the commonest sort of inquiry we get. So if we move on to the next section on chaperones, as I said, I'm going to talk about these because the specific requirements about chaperones are kind of misunderstood sometimes, and I'll run through those and run through what should be in your mind when you're undertaking an examination that requires a chaperone. As I said, and I don't want to sort of say to you that allegations of sexual assault against doctors are common. They are rare, but they're extremely difficult for all concerned if they arise. And they can take years sometimes to investigate, and that's incredibly stressful for the practitioners in those circumstances. So if we move on to the next slide with a scenario, this is really based on a case I had a number of years ago. Patient wasn't suggesting that they'd been sexually assaulted at all. They complained they felt violated, and it was during a diving medical examination. Anybody hazard, if you put a chat message in, anybody hazard a guess as to why that was. So I'll give you a second or two I talk about, we'll come back to that. So put a message in the chat if you've got any ideas, and I will talk about chaperones generally, and we'll come back to that in a minute. So if we have the next slide. So this is the GMC guidance on when chaperone should be offered. Remember, the role of a chaperone is somebody who is an impartial observer wherever possible for an intimate examination. And the GMC defines an intimate examination as an examination of breasts, genitalia, rectum, or another examination where the patient may feel particularly vulnerable. A chaperone should usually be a health professional, is what they say. I will sort of put that in context. It doesn't mean that the person has to be a doctor or a nurse. What it means is it should be somebody who is sufficiently trained to know how a procedure should be done, and you know, would be able to raise a concern if something untoward happened, and equally should be able to give reassurance that it was conducted appropriately if it was. You know, the other thing is put a note in the record about chaperones. If a chaperone was offered and declined, then do make sure you include that. So yeah, if we go on to the next slide. So in terms of key tips about chaperones, giving patients privacy to dress and undress. Remember, it might be appropriate for other types of examinations rather than intimate examinations. If you have a particularly vulnerable patient, communication is really important. Occasionally, saying things intended to put the patient at ease can have the opposite effect. So being professional, giving clear communication, particularly about why that examination is important and the rationale for doing it. I, up until earlier this year, still worked in hepatology. I've seen a lot of people with GI bleeding in my time. But until I started working for the MDU, I did not kind of think about, you know, that actually I'd explain I was going to do a rectal examination. But I obviously often wouldn't explain that if they had hematemesis, why I was doing a rectal examination. You know, so somebody was vomiting blood, the patient won't necessarily understand why you're doing a rectal examination to look for altered blood and melena. So explaining those things can help the patient understand why that should be appropriate. And remember, the chaperone should be trained. The other point I would make here is that the gender of the doctor and the patient doesn't affect whether a chaperone should be offered. When I've spoken about this before, I've often had comments such as, well, if it's a male patient and a male doctor, or a female patient and a male and a female doctor, or even a male patient and a female doctor, you know, essentially if the doctor's female, it doesn't really matter. I would say that that really isn't our experience. When we looked at this even around 10 years ago, about a quarter of the allegations were where the gender of the patient and the doctor were the same, and we're certainly seeing every combination of doctor-patient gender being the subject of allegations of inappropriate examination. So, you know, remember it's contingent on the needs of the patient and the type of examination. So returning to the first scenario, we asked about why that patient felt threatened or felt violated, and I've got a suggestion here. Maybe the patient was forced to remove face coverings for the fundoscopy. That's a good point, but wasn't the issue on this occasion. This was simply because the patient had got undressed for a general examination, and in this case, the fundoscopy had occurred with the doctor, you know, obviously close to the patient as you need to be for the fundoscopy, but the patient hadn't redressed between the general examination and having the fundoscopy undertaken, and they found that uncomfortable. Now, you may think that's reasonable or unreasonable, but just remember, everybody reacts differently to these situations, and sometimes people are uncomfortable in situations to us which are really familiar. So if you're mindful of that, it'll kind of help you through this sort of think your way through these sorts of issues and how to approach them. So the next slide on professional boundaries. I'm going to talk a little bit about this. Yeah, thank you. 27 will be great here. So a few questions that we're often asked is, look, you know, is it legal for me to prescribe for myself? Can I prescribe for my family? Can I prescribe for someone that I work with? And again, I'm conscious that in a lot of you know, in a lot of circumstances, if you're doctors, you will get requests from family. And it's almost expected that you will be able to help, and it's maybe seen as bad when you can't. But again, we have very clear guidance and precedent from the JMC about this. If we go on to the next slide, you know, that they kind of talk about, you know, if you're ill, then you're not your own doctor. You know, that if you think you've got something that you can pass on to patients, or if you've got something that affects your ability to work, well, you've got to take independent advice about that. So that's plain, and I guess that would be obvious. If you think you've got a condition that could be transmitted to patients or impair your judgment, well, you should get independent advice. Of course you could. I don't think we'd argue about that. Now, they also suggest that we should be immunized against serious communicable diseases. And this bit is the bit that's important, is you should be registered with a general practitioner outside your family. And I'm sure most of you will know, but essentially that general practitioners are in primary care in the UK, and at the present are the gatekeepers for most other services. And the idea, and typically, you know, when I came to this country in about 1980, 78, 80, you know, it was really common for parents who were doctors to register children at their practice, or at a family member's, you know, or a friend's practice. That's really discouraged now. It's intended that all medical care should be independent, and that we access medical care in the same way that other patients should. So be mindful of that as well. So yeah, next slide, please. And again, there's also very clear advice that we should avoid providing medical care to ourselves or anyone we have a close personal relationship. Now, wherever possible I again need to put this in context. Wherever possible means that we apply a really high threshold for that. It doesn't mean it wasn't possible for me to see my GP because I was on call tomorrow, or it was inconvenient, I'd have to miss work, or I'd have to arrange time off work. That's not really what it's talking about. What it's talking about is circumstances such as if you're in an isolated setting, you're working, you know, you're a doctor on an oil rig, or you're a doctor on a remote island in the north of Scotland, where, you know, you're the only doctor, your family also live on the island. You may be compelled to give treatment in that situation, but it's not intended as a convenience thing. And similarly with prescribing, if we go on to the next slide. There's also really clear guidance about avoiding prescribing for yourself or anyone else you have a close relationship. To put this in context, this really stems from cases spanning over decades in the UK, where there were issues with doctors prescribing inappropriate prescription medicine, sometimes dependence-inducing medication for themselves or family members. And this sort of has become a stricter and stricter sort of prohibition over time. So to the next slide. So I think, you know, that you know, around the world it will be frowned upon for a doctor to have an improper relationship with a patient or anyone close to them. So I'm not going to labour that. I think it's also important to remember that in terms of relationships with patients, there is also guidance about things like gifts. And that exists from the GMC. Usually you have it from your employers as well. And it's usually the point is that you shouldn't accept a gift where there is a chance that there's even a perception that, you know, that gift could affect the treatment that a patient gets. Now, it's not banned for you to accept a small token of appreciation from the patient. But for anything more substantial, most organizations have a process where you can declare that and have it registered as a gift and get advice on whether you can keep it or not. We are also sometimes called for advice when doctors get unwanted attention from patients and how to manage that. And it's usually best we generally say, if for example, if it happens in a GP surgery, that ideally that doctor should be shielded from having to interact with that patient, and instead somebody else should do the communication to say, look, you wrote to Dr. So-and-so in these terms, you know, ask them out on a date or whatever. That's not appropriate, and you really shouldn't do this again, and for these reasons. The other thing to be mindful of is social media. Again, it goes back to the point that doctors aren't ever really fully off duty. So, you know, you've got to conduct yourself reasonably and respectfully on social media. And the JMC also say that if you use social media and you're commenting on something as a doctor, you should identify yourself by name. That's not really so that you can be held to account. It's really to try and stop people who aren't doctors at all, you know, purporting to be on social media, because if someone puts their name on social media and say, look, I'm Dr. X, it's actually quite easy for a patient within a few seconds to look you up and see whether you are a doctor or not. You know, so I know that's a double-edged sword, but be mindful of that your standard of behavior on there is expected to be similar to how it would be in other settings. So thanks for that. If we go on to the to the next slide from there, I'm going to talk briefly about consent. And again, the idea of this is not at all to make you experts in this in one session. It's really to say, look, this is a really big topic, and it's something that when you're getting consent for procedures, for treatments, for even examining patients, etc., these are things that you should think about. Typically, when we get questions about this, I can break them down into consent in adult patients when people ask about, well, what risks should we explain, you know, etc. That there is also issues in relation to consent in children, the stage at which they're able to give their own consent, or which parent can give consent in that setting. And there's also another big and complicated area about who can give consent for somebody lacking mental capacity, or how do you make decisions about patients who lack capacity. So think of it in that framework. So if we have the next slide. So in the adult patient, the basic position is, of course, us as adults, we're free to decide what we want. We can make unwise decisions. We can refuse treatment. You know, even when that puts our life at risk, providing we've been appropriately counselled. So essentially, in some ways, this is very straightforward, but much of the debate in the UK and law really since for the last sort of, you know, 70 years has focused on the question typically of what does a patient need to be told to give properly informed consent for a procedure or an intervention. Before probably about 7, 8 years ago, the view in the UK, certainly by the law, though not by probably how most doctors approached it, or the GMC as the regulator, was that, you know, we as medical experts would be in a reasonable position to decide what information a patient would need to make decisions about their care. That's really changed over the last few years, and the focus is very much on a patient-centered approach. So if there's ever a legal question about whether valid consent was in place, the focus is really on whether a reasonable patient in that person's position got the information they would have expected. So it's kind of, you know, there may be a lot of overlap in the information, but the concept has moved from something where we as the experts know what a typical person should need to know about this procedure to what a reasonable patient might expect in this setting. So if we go on to the next slide. So I apologize, this may be a little small, but this is the guidance that's been in place from the GMC for about 3 years. It doesn't say anything earth-shattering, but it has these principles which essentially say that you should involve patients as much as possible in decision making. You should share information about serious complications or what a reasonable person in the patient's position would want to know. That if you come to know that something is really important to that person, say they have a particular occupation that would make a complication of surgery particularly difficult for them, or a particular lifestyle that would be affected by a complication, then there's an onus on us to kind of share that information. That where somebody might struggle to make a decision, you've got to support them as best as possible in that, using communication aids or whatever other adaptations they need to do that. And this point where they say the choice of treatment or care for patients who lack capacity must be of their overall benefit, or otherwise termed as best interest, that's really an expression of the law in the UK about how you make decisions about patients who lack capacity, which we'll come on to later. So I'd say that's a reasonable source of information because it does do a brief review of the law as well. But then I'll go and talk to one of those complicated areas, which is children. So think about this scenario. A 7-year-old attends the A&E department with a fractured ankle sustained during a football match. Parents are divorced and the child normally lives with their mother. Child needs an operation. The father gives his consent, but you cannot reach the mother. Can you proceed? So answers in the comments, but we'll go on to the next slide to do the background, and I'll return to that at the end. So yeah, slide 37, please. So you can treat a child if that young person has the capacity and has consented to treatment. So this is to do with their level of maturity, etc. There isn't a cut-off age, but you know, typically children much under 11 aren't typically able to give their independent authority, but it will still really depend on a case-by-case basis. Certainly as they get older, the expectation is that they will have more involvement in their decision-making. Occasionally, and you may read about these in the international press sometimes when this comes about, but if a doctor is, if there's an intractable dispute between the medical team and parents, sometimes the courts intervene to make treatment decisions or to authorize treatment decisions about patients who are children. Occasionally, you know, you can provide treatment in emergency if it's needed to really preserve life or serious deterioration in the condition of the patient. So immediately necessary treatment you can certainly give when you can't reach the patients. So, and we've got an answer here saying if it's not urgent, it can wait until the mother is reached, or maybe depends on who has legal custody. There's lots of important points there, and I'll come to those. The concept in the UK of parents being able to give consent rests on a legal concept called parental responsibility. That's, again, something I think that might be distinct from many other countries in that it isn't exactly paralleled with who has custody of the children or who is even responsible day to day for the children. It's a technical term that has a definition. So if we move on to the next slide. So a person, you know, these are the classes of people who are granted parental responsibility. So here, the birth mother, married fathers, even if there is subsequent divorce, unmarried fathers, if they're named on the birth certificate. It's possible to enter into a parental responsibility agreement with a person who has parental responsibility to acquire it. I've not ever seen one, but that's possible. Adoptive parents have parental responsibility. So if you adopt a child, you, of course, are granted this legal status for them. And other bodies may have parental responsibility as well as parents. So if a child is taken into care by a local authority, the local authority will typically share parental responsibility for that child. If you give your child up for adoption, you no longer have that, and parental responsibility can sometimes be removed by a court if it's decided that you are effectively an unfit parent. Typically, go back a slide. So typically, it's the scenario that we've got. I think there's a lot of important points there, and I think the one that's sensible here is that if you've got non-urgent treatment, there is no harm at all in trying to get the agreement of both parents. Technically, for most treatment decisions, you can rely on the authority of one parent who has parental responsibility. If you know that there is a dispute, then I really advise against proceeding with one authority. I would typically suggest that you know, clinicians do their best to say to the parents, particularly for non-urgent treatment, that they sort out the dispute amongst themselves in the interest of the child and come back. Those situations can get messy, and we always say, look, call us for advice if these aren't resolved. The other thing is that there are some treatment decisions which are said to be of a particularly contentious nature that require the authority of both parents. And an example of that can be some sorts of vaccination. It can also be non-therapeutic circumcision. So typically for, say, a religious circumcision, they would need to be the authority of both parents, both individuals' parental responsibility to proceed. And of course, if there is only one parent with parental responsibility, you can rely on that. So next slide, please. So again, I'll talk about this for no better reason than actually it's quite a common scenario that comes up in exams and questions. It's about whether you can provide abortion, sexually transmitted infection advice and treatment without parental or knowledge or consent to young people under 16. And these are the conditions that have to be fulfilled. They understand the treatment, that they should have been persuaded, that you should make attempts to persuade them to tell their parents or allow you to tell them, that they're likely to continue to have exposure to risk without the treatment, and they're likely to be adversely affected if they don't get the treatment they need, and it's therefore in their best interest to proceed. This is expressed in what you might think is quite an old-fashioned way, because it's really based on a case called Gillick from the 1980s, where a mother tried to challenge the local authorities' position in terms of putting forward people for treatment in this context. She failed in that challenge and forever has had a judgment named after her as a Mrs. Gillick. And these are the characteristics of a child who is termed to be Gillick competent to consent to their own treatment in this context. So the next thing I'm going to move to, if we go on to the next slide, is refusal of treatment. Now, this is one of those situations which is difficult because the law is unclear. Okay. Now, although you'd think we'd be getting calls about this all the time, we really get very few calls about this. So essentially, people tend to work things out in pragmatic terms. Either a child who is refusing treatment that they need will kind of be talked round to do that, or people will take the view that actually if somebody who is a teenager wants to do something, that they can't really force them to have it without perhaps causing further injury. But it's one of those areas where the refusal of a competent child, as it's called, so somebody who's between 16 and 18 but refuses treatment, it's an odd position of law in the UK. So a 16-year-old by law the default position is they can consent to treatment. Unfortunately, the position about whether they can refuse, particularly if their parents want them to have the treatment, is confused. Now, we seem to have lost the slideshow, Alvin. I'm not sure where that's gone. I've just got a black screen. Maybe if you, stop sharing and reshare. I don't know whether that might work. Guys, can you see the slideshow? It may just be me, in which case I could just continue with my own sort of presentation open, or are you seeing a black screen as well? Right, I think we're back on. Thanks, Alvin. So we're going to really wrap up with a couple of topics. I've got a couple of slides, I think, with social media at the end, but I'm going to talk about mental capacity. And again, now, guys, can you see the presentation again now? Because I can. Yeah, fixed. Perfect. Thank you so much. So we're going to do mental capacity next. So if we move on to the next slide. So mental capacity is essentially whether somebody has the kind of mental ability to make decisions for themselves. Now, the complexity of this is that England and Wales, Scotland and Northern Ireland each have mental capacity legislation. Northern Ireland has had this in draft form for some time, but they have had problems with their assembly and forming a government, so that only parts of this are in progress. Now, the questions, we had a webinar at the MDU on this a couple of weeks ago, and the questions that people often ask me is, look, what questions do you ask to test whether someone's got mental capacity? And I would say that I entirely understand why that question's been asked, but you need to think about this in a fundamentally different way. There isn't a standard set of questions you can ask to determine someone's mental capacity. The questions that we asked in things like a mini mental state examination or tests of orientation and cognition might be relevant to whether you ask yourself whether the patient has capacity or not, but they never fully determine it. And I hope to be able to communicate why here. So the starting point for law is that as adults, we basically start off with the law saying, look, you've all got capacity. You know, you've all got the capacity to consent or refuse medical treatment or make other decisions, unless the people you're seeing have reason to think that you don't. Okay, and if there are things that make you think that the person's capacity may be impaired, then, you know, the onus is on us as practitioners to make that assessment. Why I say that you can't make assessments of capacity based on a string of standard questions is that capacity is time and decision specific. So, for example, it might mean that if you've got a retired, a retired business mogul with, you know, millions and millions of pounds of assets, and they get a degree of cognitive impairment, they might have capacity to manage their day-to-day finances, but not to decide what to do with their investment portfolio, etc. And it's similar for medical care. People might be able to make decisions about more minor things, but may not have the capacity to make bigger decisions. So essentially, when we assess capacity, we're assessing whether they can understand the information, at least the basic information they would need to be able to make the decision they need to make at that time. Okay. And as I say, the decision to, you know, the inability to make complex decisions doesn't mean you can't make other decisions. Okay. So this is how the Act in England and Wales states. It states that someone may lack capacity if they're unable to do one of the following. I'll go through those. I will say, though, that this must arise from a disorder of brain or mind. It can't just be, say, for example, if someone's asleep, that's a physiological state, they won't be able to do those things, but that's not a disorder of mind and brain. So it has to happen for that reason. So they need to understand the information relevant to that decision. You know, and they should be able to understand also that if they fail to make a decision, what the impact of that be, and that might be particularly relevant for urgent situations. They've got to be able to retain the information in their mind for long enough to let them to use or to weigh the information as part of a decision-making process. So they've got to retain it for long enough for them to kind of work out in accordance with their own priorities what that should be, and they should have a means of communicating that decision. Now, this may be typically by speech in sign language, or it might, for people with significant neurological conditions, be with augmented communication or simple muscle movement. Okay. Now, this is on the balance of probability. So if you think it's more likely than not they can't do one of these things, then they may lack capacity. There's a very interesting variation to this in Scotland, which had mental capacity legislation before England did, where they also say that the person should be able to remember the fact they've made a decision, which in practical terms is probably a sensible thing. But that's not a requirement in England. Next slide, please. So if a patient fails the test on those criteria, then essentially we have to make a decision in their best interests. The person to whom that decision falls is really the person who is planning the intervention. Okay. Best interest is a term defined in law. It's not just medical best interest. It essentially requires us to consult widely with all of those people who might have an interest in the person's welfare and try and work out what's best, what's in their best interest. Now, this might be really typical, if easy, if somebody has had a road accident, is unconscious, they need to go for a laparotomy. That's a reasonably easy decision. It may be much more difficult, say, if you've got a patient with multiple comorbidities, who's elderly, who's always prioritized living at home, who might need to go into hospital for investigations. And often that's resolved by having a group of people have a best interest meeting, including their family, care workers where they're resident, etc., and come into that. Now, I can only really touch on the concept of mental capacity here. There's lots more about advanced refusals of treatment. There are particular requirements about serious medical treatment when the patient doesn't have anybody but paid carers to sort of speak for them. We've really not also touched upon the fact that if you're, in that context, say the unconscious patient, you would typically, if you're making decisions in the best interest, you do what's least restrictive of their future options. And what that means is that you're going to do the most limited treatment that's still compatible with the purpose of saving them or saving a limb or what have you, but that doesn't necessarily, that gives them most scope for making decisions in the future. And if you can safely defer some other steps in their care till they may recover, then that's what we'll do. It is a complicated area, but I just want to introduce that concept. And there's some e-learning on our website, but there's also a webinar recorded from a couple of weeks ago it's on YouTube on the MDU video channel that you can check out if you're interested. So I'm going to wrap up with some comments about social media. So yeah, next slide after that. And I say this because I think it's one of those very, very avoidable causes of difficulty for doctors. I wouldn't say doctors getting themselves into trouble all the time. It's not that it's banned or that you can't express yourself. It's just that sometimes you can see that things have developed that really needn't, that cause trouble. And essentially, the fundamental thing to remember is, look, if you wouldn't communicate in the way that you would with an individual, like in a face-to-face interaction, don't do that on social media. So if we go on to the next slide. So the risks of social media as we've seen them is that it can blur personal and professional boundaries. I've got a colleague who's very switched on with this, and with minimal amounts of information and access to a social media profile, she has a game where she can tell us all sorts of things that we didn't really know about ourselves, or things about our life that you didn't think would be obvious from what you'd put on Facebook or whatever. Patients can contact doctors directly. That can be difficult. They can leave negative feedback on forums that it's usually only appropriate to deal with offline. You can raise issues of respect for colleagues if you do that. You've also got to be careful about straying into individual medical advice. It's not saying that you can't express a view or a comment about a medical condition or procedure or innovation or what have you, but it's really easy in conversations online to stray into giving specific individual advice about a patient, to a patient about a condition, or to a colleague about an individual patient. And that can be very difficult, raise very difficult issues, practicing across jurisdictions, indemnity, all sorts of things. The other thing to be mindful of, particularly of unusual cases, is that accumulated information, say in a case report or something put on social media, can lead to identification of a patient, or just as difficultly, it can lead to somebody thinking that it's about them when it's not. Okay, and those things can be difficult. So the next slide. So, and remember, this is a very long way of saying, look, remember it's there forever, and remember that, you see this with, whenever somebody gets to a position of prominence, we now, it seems a ritual that we bring up their tweets from when they were 16 and scrutinize them. And remember that as a doctor, that can be extremely difficult. So next slide, please. Again, this is just simply to say there's a lot of GMC guidance again about this, and not because it causes a huge problem, but actually because there was a call for some degree of clarity from the profession as to what they could or couldn't do. So the next slide. So the final things I'd come to, is really the kind of strapline we talk about. What do defence organisations do? Why might you want to join one? And it's ideally that I think the most useful thing we do is to give some support before things go wrong. When people ask us a question of, look, I've got a tricky situation, how should I handle it? What we always want to do is to try and prevent that situation getting worse or escalating. So next slide for that. In terms of what we do, of who we are, we're 40 doctors and a range of specialities, from general practice, clinical genetics, neurosurgery, etc. We're spread over the UK. We get more than 20,000 calls to the medico-legal telephone advice line. That's, you know, doctors and dentists calling us about medico-legal questions, you know, anytime, day or night. And we get approximately 10,000, that's just in the medical side, new case files a year where a doctor has a serious, more and more serious issue where they want written advice, say, about a complaint, a GMC case, occasionally a police investigation. And next slide, please. So when things go wrong, sorry, next slide. You know, there is a thing called the duty of candour across now all UK jurisdictions that kind of requires NHS organisations to be open and honest with patients when things go wrong. And actually, this is quite a clumsy piece of quite bureaucratic legislation. And our real point about this is that doctors, since you know, for about 30 years, have had an obligation to do that through their GMC obligations, to be open and honest with patients when things go wrong. And that often helps diffuse things if it's done in the right way. Next slide, please. It can be quite difficult to do and to phrase appropriately, and we can certainly give advice on that. It's often sensible to apologise. There's been a lot of fuss about that, given a case that the GMC had last week. But as much as their approach to that was clumsy, the other thing that can often go wrong is an apology for, you know, an apology if clumsily phrased can worsen the situation. You don't have to say sorry when you've not done anything wrong. In that case, you can offer empathy and explanation. But where something has gone wrong, giving a meaningful apology is more likely to diffuse than not. So if we move to the next slide. So I've put there that the last slide had the kind of professional duty of candour, what the GMC expects, which is straightforward. There's a duty of candour that organisations have, which is more bureaucratic, requires more record keeping. In general terms, from your perspective, what you need to do is to be able to flag up an incident, an issue, an adverse event, a wrong prescription or whatever, so the organisation can look at that and see whether they need to follow this process. So the next slide, please. You know, the problems we see can be if there's a failure to report an error. Amendments to records are really, really difficult. If you ever make an amendment, don't sort of cross stuff out, write it again, write it, you know, make clear it's a retrospective amendment, include why you made that, why you're making the amendment, and make sure it's timed and dated with the current date and time. Because otherwise, when patients see amendments to records, you know, if they've suffered harm, but all sorts of thoughts come into their head that there's been some malice behind this and why it's happened. It can be very, very difficult to undo. The other avoidable issue is about not taking enough care when completing reports. The thing I would say is, although I've been doing this job for 15 years and had literally thousands of cases, when that case first comes in, yes, there are one or two you can tell are going to escalate. Others, it's actually very difficult to predict whether something will be resolved or something won't. It doesn't always relate to the severity of harm that came to a patient or at all. It can depend on how motivated the complainant is, etc. And if you know, and you guys, when you're busy, you'll always be asked to write a report and send it back this evening when you've not had access to the notes, etc. Often taking a breath, saying, look, I'm really happy to help with this process, but I want to see the records. I want to have a think about it. I want to take advice, and I want to do a proper job so that if this escalates, everything that's in my first report is accurate. I'm not having to backtrack on it. That's really, really important. So for the last few slides, I'm talking about, you know, kind of the common things we see. You know, often clinical management is often there. Often something has happened that's not been the outcome the patient wanted. So there may be issues relating to clinical management. But often these other things, communication, chaperones, dealing with confidential information, the content of the records, either with it being, you know, the accuracy of them being disputed or them being inadequate, or indeed a doctor having written something without kind of thinking that actually patients essentially can access all their records. All they have to do is ask, and it may well be proactive and online in future. You know, being frank when things go wrong, and also consent, because of the changing approach, is really important as well. So for the last section, so we've covered the substantive work. It's, well, why join the MDU or a defence organisation? If we go to the next slide, we'd say, look, it's not that you should practice being fearful of medical legal consequences. It's really that you should just do your job, but have somewhere to go to if you face any of these sorts of issues. You may hear that the indemnity provided by the NHS is enough, but actually it only covers this process, civil claims. It can sometimes support you with a complaint or in a coroner's inquest, providing your interests are aligned with your employer. If you're somebody who's, you know, if they say, look, we think you did this wrong and you don't agree with that, that does put you in a more difficult position. And the next slide, please. And this is simply to say, look, these are the sorts of things that we can, that a defence organisation would tend to support you with, whereas the NHS only would do. And as I say, these things in terms of complaints and inquests really depend on how well your interests are aligned with that organisation. So next slide, please. So of course, look, I'm the head of the advisory departments at the MDU. Of course, I would say, come and join us. We're the best, etc. And this is kind of why we say that. In all seriousness, I would say, look, I'd far rather you joined somebody than nobody. It's ultimately your decision. If you don't have any work that is effectively private work, if it's all within the NHS, you might not need indemnity for claims outside what you're giving in the NHS. The only thing I would say is there are two really bad reasons for not joining an MDO. The first really bad reason for thinking I don't need it is that this will never happen to me. It may well not, but you really can't tell. Or I'm a good doctor, so I will avoid these problems. You know, it really doesn't quite work like that. I've seen a lot of really excellent doctors find themselves in considerable difficulty. The other thing to say is that, you know, the other reason is thinking, you know, that that the NHS's cover is enough for those other processes, because it isn't. So, you know, I'd say, look, yeah, you know, we are the MDU, we're here to help. You know, and of course we'd love to join you, but on a more serious note, look, think whoever you pick, you know, think carefully before saying, look, I don't think I need this, because you might do. So I'll stop there, Alvin, and hand over to you.
Okay, well, thank you so much for such a sort of overarching and actually quite in-depth webinar on sort of indemnity cover and quite common legal scenarios that you may encounter. And obviously, sorry for all the technical difficulties.
Oh no, thank you for your help with that. I think that I hope it was you could see it on there. I was just trying to see whether, and if anybody in the wants to put any questions in the chat, I'm very happy.
So we have some time for questions if anyone would like.
Yeah.
To put them in the chat, if we can wait a bit. Otherwise, I can start with some. So specifically, there the MDU provides sort of phone services and online services that you can gain some, I guess, legal input from. But during work, in the sort of more acute setting where you actually encounter this, obviously retrospectively you might be able to talk about these scenarios, but within a hospital or even in primary care,
yeah,
what sort of resources are available for practicing doctors?
So I guess the first thing I'd say is it's always sensible to talk to a senior colleague. They, you know, that it's obviously the case that sometimes there are you know, I love this job because it's like medicine. You get an infinite variety of the same thing you've seen 100 times. There's a subtle difference that makes it unique, and you see that in the medico-legal sphere. But actually, you also see the same thing over and over again, and a lot of your colleagues will have, you know, will have done that. So that there is that. You know, trusts have legal departments, etc. But I would say that actually, look, you know, that during the daytime we typically answer our phones within about 20 seconds. So if you need to talk to us, we try, you know, I'm not saying we can do that every single time, but we try and be available, because we know that sometimes, you know, I've had calls when they say, well, the patient's in the room with me, or the police are at the surgery, you know, and they want to know this. And often actually those scenarios aren't actually that complicated. They're stressful for you, but they're not. You know, but often the medico-legal part is straightforward, and often what that person needs is, look, you know, this is what they're going to say to you. You might perhaps just want to say to the officer, look, I'm very happy to help, but I need to think about these things. Can you give me this information? Could you please give us this request, etc., and do that? So I'd say, look, senior colleague, call a defence organisation. Bigger organisations may well have people charged with doing certain things. If you've got a bit more time, particularly in a big hospital with a complex issue, say of mental capacity, they will often have a whole team that can help you work out how to maximise a patient's capacity, what help to give them, etc. So that sort of thing is all completely possible.
Okay, thank you very much. We actually have some questions in the chat. So
yeah.
Oh yes, you can see them, can't you?
Yeah, so I've got Pietro sort of asking, could you tell us in a nutshell what would constitute for punishable negligence for an FY doctor, and what's the rationale behind it? So I wish I could have my multiple jeopardy slide up again, because the concept of negligence relates to civil claims, and there isn't an element of punishment in that. You know, so a patient sues a doctor, sues an organisation, typically sues the NHS. And essentially, the standards are that you know that there was a duty of care from that doctor to the patient, or the organisation to the patient. That's almost always the case in medicine. But there was a breach of that duty, so the treatment fell below what a reasonable body of medical opinion of opinion would have supported. That failure to give treatment caused harm to the patient. And the punishment or the compensation is not really there to be punished, certainly not in the UK. There's not really a concept of punitive damages of, gosh, this person did something really bad, so we're going to compensate you much more. It's really to try and put the person back in the condition they were, but for the harm they've suffered. So it's why, say, for some example, that's why spinal claims are so great, because the compensation is not to punish the surgeon, but to say, look, this person may be paralyzed for the rest of their life, there'll be all sorts of adaptation needs, etc., that goes on, and that's what amounts to the compensation bill. Now, so in the concept of negligence, look, think of that's a civil claim. It's about compensation, not punishment. In the context of where people are punished, well, you know, the processes that do that can either be if there's a police investigation, and that's, you know, rare and a complicated sort of scenario. So it's hard to sort of do that in a nutshell. The other commonest thing we talk about is a regulator, and they have the ability to punish because they can suspend a doctor's registration, stops them working for, you know, a month, 2 months, a year, which is a huge fine effectively, as well as the personal stress of all of that. Or they've got the ultimate sanction of removing a doctor's registration. For that to be engaged, the standard that should be applied is that the doctor has fallen seriously below the standard of a doctor of a similar stage of training. So it shouldn't be that you've got a really difficult clinical call wrong. It should be that foundation doctor has repeatedly and seriously been below the appropriate standard for an FY1 doctor. I would also say that typically where it's clinical performance, particularly if you're an F1 doctor, it's likely the outcome is not likely to be punishment of that type of suspension or erasure. It's much more likely to be that you have to agree a specific plan of working within a remediation program, either through agreeing to do that or being forced to do that at the end of a process. But it's much more likely to be something that is done through a kind of, well, you need to show us that you're working under supervision, you're doing these things, etc. So, and of course, that's often why for more senior doctors it can be even more serious, because in order for them to return to fully unrestricted practice if they've gone through a GMC process, they have to show that they are able to function independently, whereas really for a doctor in training, they have to show they've got to the appropriate, so they can be managed as any other training doctor with a monitoring, annual reviews, etc., that they would get through training otherwise. So, Pietro, I know that's a bit of a roundabout answer, but I hope that's got somewhere near that.
Okay, and last we have a question with regard. Oh, there you go.
Oh, thank you. So I've got, what's the process of joining the MDU? I'm sorry the slides didn't project fully. We did have QR codes on the slides to...
I can just share the last slide, actually.
Yeah, that should have a QR code on your slide. Otherwise, if you go to www.themdu.com, I'll stick that in the chat. Then you should be able to follow the links on there to join. Oh, sorry. Yeah, so there's a QR code on there. If that, if you scan that, that should take you through to a web page that lets you follow through on that. So I can't see any other questions in the chat, so feel free to shout out.
Okay, looks like we don't have any more questions. Thank you everyone for joining, and thank you very much to Dr. Nandasoma for such a great webinar. We've just posted in the chat. If you could provide some feedback, that'd be amazing. And I hope you've enjoyed this webinar. I hope to see you all soon.
Great. Thank you very much, guys. Have a good evening.
Bye.